Hello children, I hope you all are good. So today we are going to discuss one another topic of civics, that is the judiciary. And in this chapter we are going to understand about the judiciary system of India, what type of the Supreme Court, High Court, District Court, how they are going to be function, FIR procedure and the role of judiciary, etc. So let's start the chapter with the structure and process of the judiciary. In a democratic system, judiciary is called the third pillar of government, or you can say the third organ of government, where we are having legislative, executive, and then we are having a judiciary. The Supreme Court, the apex court of appeal, high courts and the lower courts come under the judiciary of India. Means we are having the three systems: Supreme, High Court and the lower court. Supreme Court is referred to as a ultimate interpreter of law. The right of citizen as guaranteed by constitution are protected by our judiciary. In the previous chapter I have told you, if anybody is going to violate your fundamental right, you can directly approach to the court, to the judiciary. Now what are the structure of judiciary in India? The Indian judiciary comprises of network of lower courts or judicial bodies. Hence, it consists of pyramidal structure. You can say this pyramid, okay. At the apex of the pyramid, that is the Supreme Court. So, pyramidal structure means at the top there is a Supreme Court. And then below you can see the High Court. High courts are prevailing in the different states. States are having their high courts. And then High Court, after High Courts, cases introduced into the judicial system follow the predetermined course in the sense of all cases. After High Court we are having the District Court and then subordinate court. So we are having the chain of the courts here. Now you can see that at the apex of pyramid we are having Supreme Court. Then below is having High Court. So cases introduced into the judicial system, what they follow? They follow a predetermined course in the sense that all cases from the lower court will be taken for appeal to the higher court and ultimately to the Supreme Court if it is accepted for the adjudication. Means if you are having a file a case into the lower court and you are not satisfied with the judgment of lower court, then you can appeal to the High Court. And then again you are not satisfied with the judgment of High Court, then you can move to the Supreme Court also. That is the chain of judiciary system of India. Now moving to the Supreme Court, how the appointment is done. Current sanction strength of the Supreme Court of India incorporate the Chief Justice of India and not more than 34 other justices. Yani CJI of India and then 34 judges of there, all appointed by the President of India. The tenure of Supreme Court judge lasts till he attained 65 years of age. After that he or she retire. Now qualification to become the Supreme Court judge. In order to be appointed as a judge of Supreme Court, a person must be a citizen of India, number one, and must have been for at least 5 years a judge of High Court on any state for 5 years, or an advocate of High Court for at least 10 years, or he must be the opinion of the President and distinguished jurist also. So that is the qualification. How can we remove the judge? A Supreme Court judge can be removed from the office by the order of the President if he or she found guilty or misusing the power, misusing any rule, regulation. The procedure of impeachment motion of judge is the same as the President. In the Parliament, impeachment motion will introduce, and then in impeachment motion there will be the voting. If by 2/3 voting in the both houses this impeachment motion pass, then that judge has to resign from the post. Now function and power, if we are going to see, that is function and responsibility of Supreme Court are defined by the Constitution. It is clearly mentioned in our Indian Constitution that it is the highest court of appeal. It can hear appeal against the decision of the High Court. It can take up any dispute between citizen of the country, citizen and government of the country, two or more state government, central and state government, then PIL आपकी petition that can be heard in the Supreme Court. The Supreme Court has specific function within the limitation imposed by the Constitution. Now, what is the original jurisdiction? Certain petition can made directly into the Supreme Court without following the lower court or high court, directly Supreme Court. Now, such cases are said to originate in the Supreme Court, and the authority to resolve these cases is called original jurisdiction, because the directly cases originate into the Supreme Court. Now, following type of cases can fall in this category. Number 1, dispute between the two or more states, and dispute between the union government and other state government. That is the direct original jurisdiction. Now, the next is writ jurisdiction. The fundamental rights guaranteed under the Constitution include the right to move the Supreme Court for protection and enforcement of any law, any rights, that has given a constitutional remedies wala right. In that right, it has mentioned if anybody is going to violate your fundamental right, you can directly approach. Okay, so this is the writ jurisdiction, the right to constitutional remedies. In such cases, the Supreme Court can give the special order to form the following writ. Now, number 1 writ is habeas corpus. It means to produce the body who has violated the law, summon the body. By issuing such a writ, the court can order the government to produce the person physically mentioned in the writ. Often it is called the illegal detention, and order to release of such unlawfully detained person. This is the habeas corpus, means produce the person in the court. Then second, the writ of mandamus literally means we command, we have ordered. That is mandamus. A higher court issues this writ to subordinate court or an administrative authority in case they refuse to exercise their jurisdiction. Then they say is this writ we command. Then the third writ of prohibition. It is a kind of order from the higher court to the lower court to stop proceeding any case which might be beyond its jurisdiction. You cannot hear this case. This is not under your jurisdiction. So, to stop hearing the case, that is the prohibition writ. Then the next writ is writ of certiorari. That is, certiorari is issued by the higher court to the lower court to transfer a matter pending before it to the higher court. That you transfer to the higher court. Then next is the writ of quo warranto. It is issued by court to the public servant to inquire whether the person is entitled to hold that office and to ousted him if his claim is not well founded. So that is issued to the public servant. Now next is, that is writ jurisdiction. After this, we are having the appeal jurisdiction. Appeal jurisdiction means that the Supreme Court can reconsider the case or any legal issue involved in it on following condition. Number 1, if a high court certifies that the case should be tried in the Supreme Court, then appeal will be final. If the issue involves interpretation of the Constitution, if any law which is passed by the Parliament, it is in against of the ideal of Constitution, then Supreme Court can interpret. Supreme Court then and there declare that law null and void, bekar law. Okay, so Supreme Court can interpret the Constitution. Then next, if a high court changes the decision of a lower court in a criminal case and gives death penalty, then also the case can be here in the Supreme Court. So being the highest judicial body, the Supreme Court hears appeal against the judgment of high courts. So Supreme Court thinks that the law of or the constitution has separate meaning from what the lower courts have interpreted. It can change and reverse the decision also. So final decision is of the Supreme Court if appeal moved to the Supreme Court. Advisory jurisdiction. In addition to the above function, the Supreme Court of India possesses the advisory power also. This means that the President of India can refer any matter of public importance to the Supreme Court for its advice. However, the President is not bound to accept such advice, but yes, he or she can take the advice from the Supreme Court. Now Supreme Court, after Supreme Court, we are moving to the High Courts. High Courts are established under the article of 214 of Part 6, Chapter 5 of our Indian Constitution. The Constitution provides for one High Court for every state of India, but Parliament has been given the power to put more than one state under a High Court depending on the area or population which the court has to serve. For example, there is only one High Court for two states of Haryana and Punjab, that is in Chandigarh. In all the 21 courts, we are having 29 states and 7 union territories. Means depend on the parliament also. Sometimes they can say that these states are less population, so we can combine one High Court. But otherwise, the larger state and the larger population is having the one High Court. Appointment की बात करें तो High Court consists of one Chief Justice of High Court. A person must be a citizen of India, must have held at least 10 years of judicial office in any territory of India, or been an advocate in High Court for at least 10 years, or must be a distinguished jurist or renowned person in the field of law. So this is the appointment of the High Court judge. The other judges of the High Court are appointed by the President in consultation with the Chief Justice of Supreme Court, Chief Justice of High Court and Governor of the states. So by their consultation, they can appoint the other judges of the High Court. Now moving to the qualification of the High Court judge. To be appointed as a Chief Justice of High Court, a person must be a citizen of India, number one, must have held for at least 10 years a judicial office in any territory of India, or been an advocate or in High Court for at least 10 years. Means for 10 years he has to work in the High Court as an advocate. Then he must be a distinguished jurist or the renowned writer in the field of law. So that are the qualifications. The judges of the High Court remain in the office till the age of 62. See the difference? In Supreme Court, CJI is having the retirement age of 65. Here it is 62. They can resign from the post or can be removed by the President of India. Now the procedure is the same, that is the impeachment motion. Like in Supreme Court, we have followed the impeachment motion in both the houses. Same impeachment process will follow to remove the High Court judge. Now function and powers. The High Court is the highest court of the state. The Constitution empowers the High Court to issue the directions, any orders, any writ for the enforcement of fundamental rights for any other purpose. So like Supreme Court of India, High Court also enjoys the original and as well as the appeal power. Original jurisdiction means the cases which are directly came to the High Court, originated in the High Court. For example, fundamental right case ho gaye, divorce, wills, matters relating to state revenue and its collection. So High Courts hear disputes related to the state election or election petition. So these cases directly came to the High Courts, originate in the High Court. That's why they are known as original jurisdiction. Now appeal jurisdiction means both in the civil and as well as in the criminal cases can be made before the High Court against the decision of the lower court, that is subordinate court. High Court can give fresh verdict in such cases. Now moving to the supervisory jurisdiction. The High Court control and supervises the working of the lower court. How they are working? High Court is going to guide them, to supervise them. It is responsible for the administration of its own affair and as well as affair of the subordinate courts. So High Court is responsible. It is also regulate the appointment of subordinate services in the lower court. So that is the supervisory function, supervisory jurisdiction of the High Court. Now after High Court, the next lower court is the subordinate courts, or you can say district courts. A state is divided into number of districts for the better governance. The court at district level and below are known as subordinate courts. So at the district level, the administration of justice is entrusted to the three types of court. So under district level, there are three types of court. Number one, civil court. Civil court is the highest court in the district, can hear appeal brought from the lower courts. It is headed by the district judge and tries civil cases. The deputy commissioner or collector of the district, apart from exercising administrative and revenue power, also function as the magistrate of the district judge. As such, he maintains law and order in the area of administration, apart from supervising the collection of revenue and taxes from the districts. So in civil court, you can see deputy commissioner act as a magistrate of district judge, magistrate of district court, okay, and as well as supervise the administration of the tax collection. Now after civil case, criminal courts are also there. The criminal courts of district is headed by the session judge. Here it is known as session judge. Cases of murder, rogi, dacoity and other serious crime are heard by the session courts. The judge can go to the extent of awarding capital punishment also in such cases. However, his decisions are subject to the approval of the High Court also. Now, appeal against the decision of civil and criminal courts can be taken to the High Court of the state also. So, the officials of the subordinate courts and other district judges, they are appointed through the competitive exam. Means by giving the competitive exam held by State Public Service Commission SPSC, the person can clear the exam and after that directly appoint as a district court judge. Now moving to the next court, that is the revenue court. Cases involving the assessment and collection of land revenue, property tax हो गया आपका, and dealt with the revenue courts. They work directly under the High Court. अब these courts are divided into the 5 categories: Board of Revenue, Court of Commissioner of Revenue, the Court of Collector, the Court of Tehsildar, and the Court of Naib Tehsildar. So these are the 5 categories of revenue courts. The lowest unit of the district judicial administration is the Nyay Panchayat at the village level, rural area. They work in the rural area. Lawyers are not allowed to represent case in these panchayats. So in many states, such functions are performed by Gram Panchayat. So in Nyay Panchayat, there is no need of any lawyers at that function at the rural areas. Now after this, we are having the Lok Adalat. India is a vast country, big country with the 3.28 million square kilometer area, and regular courts are always overloaded with these cases. Beside the last few decades, we have seen a significant rise in the tenure and the cost of litigation. So to solve this problem, the concept of Lok Adalat has been introduced. Otherwise, what happened, beta? We have heard the dialogues of Sunny Deol, Tariq pe Tariq, Tariq pe Tariq, because our courts are very overloaded. So to solve this problem at the local level, this idea of Lok Adalat has been established. Now Lok Adalat has been introduced, comprising the retired Supreme Court judges. They are having there, then lawyers and the social worker. These courts have simplified the legal procedure. The first Lok Adalat, where about 150 cases were decided only in a single day. It was inaugurated in Delhi, December 1985 by Justice P.N. Bhagwati. So see the great efforts to solve the legal matter at local level. Now moving to the differences between the civil and criminal cases. Civil cases, these cases include conflict related to the money or the property or social practices like inheritance, divorce, etc. between two people or agencies, etc. So civil case deals with the rights and duties between the individuals. Now in civil case, the claimant brings a claim against the defendant. So in such case, the court determines whether one party has caused harm to the other party or not. If this is proved that yes, this party has harmed the another party, then court orders party to compensate the plaintiff or for the loss sustained. The losser in a civil case cannot be imprisoned, means no jail, even if he or she cannot pay the damage. Either party may appeal in a civil case. So civil case related to the property or the social issues, no imprisonment in this. Now criminal cases. These involves the offence which disputes peace, cause harm to the other member of society. In criminal cases, there are murders, dacoity, etc. The government brings charges against the person alleged to have committed the crime. And these cases involve enforcing the public codes of behavior as embodied in law. Now what happened? The law is concerned with establishing and maintaining social order and protecting the community as a whole. Now the criminal case, when they are going to be heard, they are having a responsibility to secure, to protect the community. So it's laid down the set of rules for peaceful, safe and orderly living. People that break these laws, what happen? They are punished by the courts and their cases termed as a criminal cases, because they are harmful for the security, for the safety, for the peacefulness of the society. So if they found guilty, they are getting a severe punishment as applicable to the concerned crime. This would range from simple fine to imprisonment to the life imprisonment or even execution, depending upon the provision of the Code of Criminal Procedure is attracted. In a criminal case, the defendant is pronounced, what we call defendant, guilty or not guilty. Criminal offences are dealt with under the IPC, Indian Penal Code, and also known as the Code of Criminal Procedure. So you have to remember all these terms: guilty, non-guilty, IPC or Code of Criminal Procedure. So different procedure and their rationale. Civil and criminal trials differ greatly in the procedure. They are very, very different. An important difference is that the standard of proof required in criminal cases is much higher as compared to the civil cases. Means in criminal cases we need lots of evidences, lots of proof as compared to the civil case. Since criminal cases, law is centrally linked with the issue of punishment, allegation, facts must be proved beyond the reasonable doubt, so that innocent people should not punish. Because in this we are going to give the harsh punishment also, capital punishment also, execution also. So we need to prove, justify the allegation. In civil cases, the court scrutinizes the balance of probabilities before giving judgment in favor of any party. So difference between the civil and criminal cases, law is basic part of Indian legal system. Civil law dealt with the rights and obligation of the people and what is needed to protect them. But the criminal laws dealt with the offences, their punishment. So in a criminal offence, the state take upon itself the responsibility to investigate the whole procedure, whole incidents, collect evidences through police also, to fight the case in court through a public prosecutor and enforce the punishment. Robbery, murder, kidnapping, these are the example of the criminal offences. Now criminal law therefore relates to the punishing offender and deterring or discouraging them doing it again, not to do it again in the society. In civil cases, however, penalties are not directed towards the punishment but to the prevention, cessation or correction of the harmful activity. Now let's discuss the role of police. See, the entire judicial system in our country revolves around the laws passed by the Union Parliament. Now, after laws are made, their enforcement is taken up by various government agencies. They are responsible to execute those laws. Now, police is the primary law enforcement agency, police, okay, and law enforcement essentially consists of two parts. Now what are those two parts? One, relate to investigation of facts concerning to the crime, violation of law, etc. This is mainly looked after by the police. But the second part relate to the prevention of the occurrence of crime itself. Prevent karo. The second part comes under the domain of judiciary. Apart from investigating the facts of crime, the other function of police are enforcement of law, that police has to do, maintenance of law and order in the society, prevent the occurrence of crime, curtail the crime by all possible legal means to detect and bring offender to the justice, and to serve and protect the citizens and their lives and properties. These all are the responsibilities and function of our police. Now, what is the role of judiciary? In India, the main role of judiciary is to secure a state of peace and tranquility by applying laws designed to ensure that those who are violating it are detected, tried according to regular legal procedure in the court. Yani to maintain state of peace, harmony, unity, integrity, that is the role of judiciary by applying the law design like this. Now this could range from segregation of the convicts permanent through death penalty or for fixed period in a jail from society to correction and release back into the mainstream of society. Depend on the crime. So depend on the judiciary whether they are going to give him or her the punishment, capital punishment, or they are giving him or her a chance to go to jail, correct yourself and then come back to the society with the good people. The court also helped the smooth functioning of democratic governance by exercising constitutional limits on the extent of government power. Now such limit included periodic election, guarantees of civil rights, independent environment in which you allow citizens to seek protection of their rights and redress against government action. So these all are the courts done this for the smooth governance. So now we are going to discuss about the difference between the role of police and judiciary. There is a lots of difference. The courts have a wider scope beta for action than the police. Law enforcement, it is the primarily an exercise by which police take due notice. Okay, there the incidents happened. Police go to investigate, collect the facts, evidences, etc., and then move to the court by taking the guilty. Now, thereafter, when the matter goes to the trial before judiciary, where the facts ascertained by the enforcement agency. Now they are presenting in front of the court. Prosecuting agencies, police has said this, these are the evidences, this person had done this, and now court is hearing everything, observing, understanding, analyzing each and every fact. The accused get full opportunities to present his or her argument from his side of the case. The court will give full time, the full liberty to the guilty also, to the person also who is presented in the court by the police. If the trial result in the accused person and being found that person guilty, yes, you have done this, then he or she is made to suffer a penalty as described by the court, and that is for the crime he or she has committed. So it means court give the fair trial, police produce in front of the court, and court has to listen everything, collect, analyze all the evidences, and after that the court has to give the judgment. During the entire proceeding in the court, the police have no role to play, because they are all the bench of judges, they are playing the role. Police is having a role to collect evidences, to catch the culprit, what he according to them they are there, and present in front of the court. Bas. After that, the all procedure are in the hand of court. Now, they have a direct or more or less exclusive responsibility in the tasks of investigation crime. But the rest, the courts are somewhat better placed in this regard. They can review the entire set of circumstances leading to the occurrence of crime, the process, the quality of investigation done by the police. So everything supervised by the court, enforcement agency, settlement proceeding in the court aided by the prosecution as well as the defense counsel, and finally the administration of jail with the ultimate object of re-socializing the criminal part of from the deterring him from repeating his crime. So overall we can say the police has a role to produce in front of court, but after that court is having a wide role to involve in all matter before announcing any punishment. So the ultimate object of judiciary is to secure peace and order in the society. The role, duties, power and responsibility of police with special reference to the prevention and control of crime. Maintenance of public order cannot be denied. Police has to see there should be the peace, there should be the maintenance of law and order in the society. It has to conform to the overall requirement of the judiciary to succeed in its objective as stated above. So judiciary also is the protector of the law. Judiciary also see whether the police is doing the work properly, whether there is a law and order maintaining the properly in the society or not. Now, role of public prosecutor. The underlying principle of Indian judicial system is that all crimes committed by an individual or group against other deemed to have been committed against society. Means if person is doing any crime in against of any person, that is seen as a you have committed a crime against the whole society. So consequently, the state take action to prosecute the accused on behalf of and in the interest of society. Why? The reason behind the state undertaking prosecution is to prevent the misuse of legal machinery by private person to cause harm. That's why they are using the public prosecutor. This role is performed by the public prosecutor on behalf of the state. Means public prosecutor is from the side of the government. It is not the private lawyer. It is from the side of state. Now the public prosecutor is the government's legal representative. I have told you it is not private. And this is the government's legal representative who is responsible for presenting the case against any individual suspected of breaking the law. In a criminal trial, it is the prosecution that charges that accused with definite offense. Having done so, it has the responsibility of proving it as well. If public prosecutor has said that this is the person, he is the guilty, he has done this, then this is the responsibility of public prosecutor to submit all those evidences in front of the court, so that the court can analyze those proofs. In criminal cases, the burden of proof lies on the prosecution. Okay, why? How you can say that he is the guilty? He has done this crime. So all the burden of proof lies on the prosecution. Give the proof. In other words, an accused person is deemed to be innocent until it is not proved as guilty in Indian law. You cannot say that he or she is the criminal until you are not able to prove him or her guilty. So give all the evidences in the court. Now the public prosecutor's main aim is to play impartial and neutral role. Though he is a public prosecutor, so it doesn't mean that when he is going to present the case in front of the court, so he can be the partial. No. He has to impartial, neutral from both sides. He cannot take the side of this person or this person. Impartially he is going to present his view for this case. Now, all person who have been charged sheet by the police, he will work impartially. The prosecution and the police are completely different as agencies. The prosecution cannot be a part of any investigation done by the police. During the investigation stage and till the filling of charge sheet, the police have control over all the proceeding. FIR to charge sheet. Once the charge sheet has been filed in the court, after that police role is over. Now the public prosecutor role will start. So he takes over all the matter. However, the proper working relationship is desirable between two. So according to the new criminal procedure code CRPC, which was effected in the April 1947, the public prosecutor is required to be an advocate with a minimum of 7-year practice. Then he or she can become the public prosecutor. 7-year practice should be there. The Supreme Court has defined the role and function of public prosecutor in various ways on various occasions. The public prosecutor is an important officer for the state government, and it is appointed by the state under the CRPC. He is not a part of any investigation agency. He is an independent, neutral, impartial statutory authority. So Supreme Court Hitendra Vishnu Thakur versus State of Maharashtra, it is a much the duty of prosecutor as of the court to ensure that full and material facts are brought on record so that there might not be miscarriage of justice. So that was given the verdict by this Supreme Court when there was a case of Thakur versus State of Maharashtra. So very well said by Supreme Court that the public prosecutor is independent. He will bring all the evidences on his own observation, on his own investigation, not by taking the side of police or any other person or any other party. Then Supreme Court of Sheikh Ala Abdul Ghaffar Khan versus Vasant Raghunath Doble also, they had given such a verdict where the public prosecutor role has been clearly specified. Now after the public prosecutor, there is one term also involved in the judiciary, that is FIR. FIR means First Information Report. First Information Report. It is generally complaint of a cognizable offense. It is lodged by the victim, whosoever is victim, or by someone else on the behalf of the victim. They can move to the police station and there they can give their FIR. They can file their FIR where they are going to give all details what happened with them. So once police receive the FIR, then only they are going to start the investigation. So this is the process in the justice, which is very, very important document. Until and unless the person is not going to lodge the FIR in the police station, police is unable to investigate that particular incident. So as per section 154 of the Criminal Procedure Code 1973, when information about a cognizable offense is given orally, the police must write down. It should be in written. If the person cannot write himself or herself, whatever he or she is dictating orally, the police has to write. Then take the signature. A person giving information, making complaint has right to demand that the record information be read out them. Whatever he speaks, the police has to read what they have written. So the FIR must be signed by the person who lodged it. It is a right of the lodger of the complaint to ask for a free of cost copy of FIR. So lodger will give the copy of FIR so that he can also see what the police has written and how the work is going to be started. It is thus obligatory for the police officer to register a case as disclosed in the complaint, and then issue the FIR copy to the person and then to proceed with the investigation. So that is the process of FIR. On information being given to the police about the commission of the cognizable offence, the police have no option but to register the case. And police has to do this. The police do not have right to refuse to register the case. No, we will not write your FIR. We are not going to register your case. No. The concerned police officer is under a statutory obligation to register the case. He has to then proceed with the investigation also in terms of procedure contained under the section 157, 156 of CRPC. Okay, once the FIR will lodge, once the case registered, the police has to start the investigation. When an FIR is registered against an accused, a copy of it is forwarded to the court under the provision of the code. If a copy of FIR is not given to the court, it will remain unaware of the offence. In most cases, however, the police refuse to lodge an FIR despite knowing the rule of CRPC. Here again the role of court becomes very important, since judiciary can question the police why they have refused to file the FIR. So here the judiciary is powerful to questioning the police and to compelling the police to register, to lodge the FIR in the case. So that ends for the chapter. Now let's discuss the important point of the chapter. Number 1, we have discussed the judiciary is one of the 3 pillars of democracy, where we are having the 3 organs: legislative, executive and judiciary. So judiciary interprets the constitution also and protect the rights of citizen also. It has pyramidal structure. Now Supreme Court has Chief Justice and other up to 25 other judges. It exercises original, appeal and advisory jurisdiction. Then we have discussed the High Court is the highest court in the state. It exercises an appeal jurisdiction. It also supervises the functioning of the lower court. And after that we have discussed the role of police and FIR. I hope you understand each and every concept of this chapter. But please do the exercise carefully.